Okay, Ms. Flores, you can start us, please.
The Court of Appeals for the 8th District of Texas is now in session.
Good morning. We're here today on one case, Marcelo Mailand from El Paso versus State of Texas, from El Paso County, Texas. Ms. Stillinger, you will present on behalf of Mr. Mailand, and Mr. Darnold on behalf of the State of Texas. For the parties' benefits, we have had an opportunity to read your briefs. We've reviewed the record, and we have had a discussion of the case already amongst ourselves. And so with that, Ms. Stillinger, you may proceed.
Thank you. May it please the court. In this case, I want to say a couple of things, introductory statements about this case. There's a lot of evidence, and I'm going to try to use my time wisely. But one thing that is important as it applies to many issues is that Mr. Mailand could not have been convicted without his confession, the statement that was taken at the jail in Pima County, Arizona. The overwhelming evidence at trial, the physical evidence at trial, was that he was not the shooter in this case. I make those two statements as a preface to many of the legal issues, that his conviction could only rest on a felony murder theory, and it could only rest on evidence that came out of his statement. I want to address the Sixth Amendment issue, which is my first issue on appeal. Mr. Mailand's statement was obtained when officers went to the jail behind the back of his attorney, with whom he had appeared in court that morning. Now, they did obtain a waiver from Mr. Mailand, but they did this without going through his counsel, who was in active litigation. So prior to Montejo versus Louisiana, it's a case that is cited many times in the briefs. Prior to Montejo, there was a bright line that said, if the defendant has an attorney, whether he knows he has an attorney or not, whether he's met with the attorney or not, that is a bright line, and the officers may not approach the defendant, and they may not get a waiver. Montejo did away with that bright line, and obviously we're not challenging the validity of Montejo. We are accepting that and embracing it, in fact, because Montejo doesn't say there's no line. They're just saying the bright line that existed before does not exist, but there is a line. And the detectives in this case crossed that line. Mr. Mailand had already received, not just been appointed an attorney, but received representation. It was actively taking place in court. I want to mention just briefly, the state several times in its brief talks about this being an abuse of discretion standard on this point. That's mentioned repeatedly. It is not an abuse of discretion standard. We are not challenging factual findings. This doesn't depend on credibility of witnesses. In fact, we're not, there are findings of fact that we do not dispute. This is a legal issue. It's a de novo review. The state, well, Judge Perez said the Sixth Amendment had not attached because Mr. Mailand had not been formally charged by indictment. That was the basis of her holding, denying the motion to suppress. I think that that is clearly wrong to say that the Sixth Amendment had not attached. Mr. Mailand had been charged in El Paso by a formal document, a complaint. A warrant had been issued. He had been arrested. He had appeared in court that morning in custody, had been admonished about the capital murder charges. He had a bond hearing and was denied bond because there was a capital murder charge. Clearly, the Sixth Amendment had attached. Now, I don't know, the state actually just says it in the summary of the argument. They say Sixth Amendment had not attached. The state doesn't mention it anywhere else in the brief. It's only a line in the summary of the argument. So I actually do not know if the state is taking that position, but I don't think that is a tenable position to say the Sixth Amendment had not attached. Yes, sir.
Counsel, if I can interrupt you just so that I understand. I think we could agree that if Mr. Mailand had been represented by an attorney on say like a personal injury case, or he'd been represented on some other criminal charge, that you wouldn't have a problem with the police officers talking to him. In other words, does he have to be represented on this case?
Correct.
Okay, and so is there any authority that an extradition proceeding is part of this case or whether it's something distinct and different.
Well, so good point, because I think that is really what the state relied on the most, is to say the Sixth Amendment is offense specific. So if Mr. Mailand were sitting in jail on a shoplifting case and they come question him about an unrelated murder charge, I agree. I don't think I would have the same issue. The Sixth Amendment is offense specific, but it is not like case number specific. So Mr. Mailand was charged with capital murder. That's what he was arrested on, was a capital murder warrant. He was admonished that he was charged with capital murder that morning in the courtroom. It is offense specific. So despite the fact that there was this ancillary procedural issue, which was an extradition, I don't think that we can say he was in jail on a different offense. I mean, that's not what he was advised of when he went to court that morning.
Can I ask you to address this decision of Flores versus State, which I think is
Absolutely.
out of our court in 2009, which seems somewhat similar in that you have an extradition, except it's out of Mexico. And there was a representation by an attorney there, and then a devastating confession when he comes back to El Paso. So how would we distinguish that case?
Okay, well, here's a couple of ways you can distinguish it. One is that in Flores, the extradition process was complete. Mr. Flores was arrested in Juarez. He was transferred to Mexico City. He was there about 6 months, presumably, I guess had representation of a Mexican attorney in that process. He was flown, finally extradition was completed. He was flown from Mexico City to El Paso by the US Marshals. US Marshals turn him over to El Paso detectives at the airport. And that's when they take him to the police station, advise him of his rights, and take his statement. I think it is a very important distinction that he was not represented at the time. At that time, when he lands in El Paso, extradition is done. There is no representation at that moment. In Mr. Mailand's case, he went to court that morning. He had an attorney on the extradition charge, which was the murder charge. He didn't waive extradition for about, I think, another week. I'm not sure exactly on the dates, but it was pending for some time after that. So there was active representation. I also think, just as a matter of sort of facts, in Flores, there is no one the detectives could have contacted. I mean, they don't know who's the lawyer in Mexico. How do we contact him? Can we even communicate with him? We know the Mexican lawyer won't be practicing law in El Paso. There's a number of valid distinctions. I think probably the most important is that the extradition process was complete. He had no representation at that moment. But here's the other really important thing about Flores that I did not myself fully appreciate last night. The Flores court did not say that it was okay. They said the error, if any, was harmless. Because after Mr. Flores got to El Paso, when he's sitting at the El Paso County Jail, he wrote a letter to a friend and he detailed the murder and all the grisly details in that letter. And so what the court said is they made a lot of statements, the court made a lot of statements, but they actually did not find that, that there was not any error. They said the error, if there were any error, it would be harmless because we had this very detailed, completely admissible confession. So that I think is the other important thing. I'm not sure, I don't actually think that Flores has the precedential value that it appears to have when you first read it, Donna. The other thing I wanted to say about the issue with respect to the confession is that if this issue is not reversed, if the court does not find a line that officers cannot cross, I don't believe that there is anything to prevent an officer from going to see a defendant at the county jail anytime. They could go see a defendant a week before trial. Now, they can't badger, there would be a voluntariness issue, But if it's okay to go see a defendant behind the back of his attorney who is currently actively representing him, that would open floodgates. And that cannot be right. The right to counsel is sacred. And all Montejo did was say that just the act of appointing an attorney doesn't amount to invocation of rights. One of the things Montejo says, and this is quoted in Flores, is that if there is an invocation and the officers thereafter approach the defendant and seek a waiver, that will not be a valid waiver and the statement will not be admissible. So there is a line. Now, Mr. Mailand did not invoke, he did waive, but what I am saying is that if you have been in court in a contested hearing, which that morning he had a contested bond hearing, the bond was denied because of the capital murder charge. If you were in court in a contested hearing, that is the equivalent of an invocation. That is the line where officers can't then, stop somebody in the hallway when they're leaving the courtroom. Hey, you want to talk to us without your lawyer? They can't do that. And that's what happened here. I think, Your Honor, with respect to the extradition being a separate case, I think I've addressed that. I think it is offense specific, not case number specific. I know I need to move on to my second issue because unless there's any more questions on that topic before we move on. Okay. With respect to the confrontation clause is our second point we raise. And just a little background on this, when Mr. Mailand is questioned by detectives, those detectives say, Mr. Nava, now Mr. Nava is the co-defendant, I'll call him the co-defendant, it was indicted under a different case number, but he is the other actor, the co-defendant. The detectives tell him several times, Mr. Nava said, you're the one. Mr. Nava said, you did it. Now, the most incriminating evidence next to a defendant's confession, I think the most incriminating evidence is from the co-defendant who was there and participated and puts the finger on him. We raised this issue in advance of trial. I raised it in a written motion with enough time so that the state could edit out, because I knew they wanted to play the video. We wanted to give them time to edit out those couple of comments. We clearly identified the Sixth Amendment as the basis for requesting that Mr. Nava's statements, as told by the detectives, be removed. We raised it in advance. I think we thoroughly preserved the issue, although I know the state is contesting that. First, Mr. Nava's statements were testimonial in nature. A testimonial statement is a statement that is taken for the primary purpose of establishing or proving past events relevant to a criminal prosecution. These statements were made in the course of Mr. Nava's post-arrest interrogation. And that was known to the jury. That was in the context of Mr. Mailand's interrogation. They're telling him, we talked to him and this is what he said. So there's no question that Mr. Nava's statements were testimonial in nature. What the state argued, the state proposed that they were admissible as a hearsay exception because they were not being used to show the truth of the matter asserted. The state proposed that they were admissible to show Mr. Mailand's reaction to those statements. Now, I actually think that's not really a valid reason for them to come in. I don't think that, I mean, I sort of think it's bootstrapping. Let's see how he reacts when we, present him with the damning evidence. But the real point is that a hearsay exception is different than a confrontation clause. And if it's something is an exception to a hearsay rule, doesn't mean it is exempt from a Sixth Amendment review. And I know we cited the case of Lara versus State, and that was Justice Rodriguez's decision that said exactly that. Even where hearsay is admissible under the rules of evidence, it may still be constitutionally barred on confrontation grounds. So in this case, Judge Perez did advise the jury, those statements are not evidence of guilt. But how could a jury follow that instruction? The co-defendant saying you did it, but that's not evidence of guilt. I don't think a jury could follow that instruction. There is lots of cases, including Bruton, that says when evidence is that strong and that inculpatory, an instruction cannot cure it.
Ms. Stillinger, didn't the state, I mean, wasn't their theory kind of from opening statement that we don't know who the shooter was? It could have been Mr. Mailand or it could have been Mr. Nava. It doesn't matter because they were acting together in concert somehow and therefore would have been responsible for each other's actions. If that was kind of the theory, why does the statement make that much difference?
You are correct. That is what we said, but I think one, it makes a difference because I think the jury has a very different sentiment about somebody who actually pulls the trigger and the person that just happens to be driving. I know legally it may not make a difference. And so to us lawyers and judges, it may not make a difference. To a jury, it makes a lot of difference who pulled the trigger. So that's one thing. The other thing is that I think the statements from Mr. Nava, it is showing that they did something together. It is a corroboration, perhaps, that they were there that night together. So even if it's not just inculpatory on the trigger man, it is inculpatory in the sense that it is evidence that they did something together that night. And so there's another person saying, yes, we did something together that night. Here's the other problem with that statement coming in. One of the things the state argued was officers lie all the time during interrogations. So the jury might not have thought it was true. And that's true. That's a common interrogation technique. You know, you arrest people, you separate them, you tell each one of them that the other dropped the dime on the other. I was not able, if that were the case that the officer was lying, I would impeach him on that. I'd say, well, detective, you told Mr. Mailand that Nava said that, but that wasn't true, was it? You were just using that as a ruse to get him to confess, weren't you? I wasn't able to do that. My hands were tied, which is something I explained to the court in trying to keep this out. My hands were tied. I could not cross-examine and impeach the fact that they were using Nava's statements. So his statements are out unchallenged. What they did is they were able to use the few good parts of Mr. Nava's statements, the few parts where he implicates Mr. Mailand, you know, filter it through the detectives, introduce those few good parts through the detective statements, and they didn't have to open them up to cross-examination. They didn't have to use all the other garbage parts of Mr. Nava's statements. And I wasn't able to cross-examine. I think it is exactly on point for a confrontation clause violation.
So, Ms. Stillinger, I guess you probably are addressing the point, but as a follow-up question, does it matter in this case that the form of Nava's statement is not Nava himself making the statement, but the detective saying that Nava said it?
I don't know that I did address that, and I'm not even sure I thought of that question, but I don't think that it does matter. I mean, they're detectives repeating his statement. I think the only sense that it matters is that if he had been there in court saying it himself, I could have cross-examined him. Mm-hmm. But essentially, whether they played the clips of the recording of his statement or whether the detectives just said, this is what we said, I don't think that is really a distinction. If anything, maybe being filtered through the detectives might have given it more credibility because they didn't even see or hear Nava. It was said in a forceful way from a police officer. I want to spend a few minutes on my third and fourth issues are both jury instruction issues, and I do want to spend you know what, I'm sorry, just before I leave the confrontation issue, I have to mention there's a case, Langham versus State, and it's cited in our briefs. And I just think it's very on point. It's where the state introduced evidence of past drug dealing of the defendant. And they said they did it to give background information. It was not being used for the truth of the matter asserted. And I think it's just a good illustration of why something can be admissible under hearsay, yet inadmissible under amendment. I think it's probably the most analogous fact situation. So with respect to jury instructions, first, I do want to mention the state said in its brief that we did not preserve this issue because the proposed instructions were nowhere in the record. We did clear that up. We filed the instructions. Initially during trial, they were emailed to the court. They were discussed in court. We later took that email and incorporated it into a pleading. It's in the 3rd volume of the clerk's record at page 495. So the 2 proposed instructions are part of the record for the court. They are in the form that they were presented to the court at the time. Those 2 instructions are the corpus delicti and the manslaughter, the lesser included instruction. Corpus delicti raises the 4th issue, but I want to address it first because I think it's so interesting. It's a concept I heard about in law school and really haven't had that case until this case, but this is the case where corpus delicti was an appropriate instruction. With respect to a felony murder, the cases say that the corpus delicti, it's not, the state says, well, actually the state, and I know Mr. Darnold didn't write the brief, but the state says he was convicted of murder, not felony murder, and there was a dead body, so of course there's corpus delicti. He was convicted of felony murder, and the cases say if that's the offense, the underlying felony, there has to, corpus delicti applies to the underlying felony, which in this case is a robbery. And so what corpus delicti says is that, I know you all know this, but it says that an extrajudicial confession is not legally sufficient evidence unless there's independent evidence of the corpus delicti. In this case, it must be independent evidence of the robbery. And there was no independent evidence at all, other than Mr. Mailand's statements about the robbery. The detectives ask him about it, and in fact, they push him, which I only say is important to the issue of the purpose of the corpus delicti rule. And it is good to note the Miller case that is cited in our brief. It's a 2015 Court of Appeals case where they reaffirm this is the law in Texas. Other states is not, and there may be challenges to it, but in Texas, this is the law. You have to have some independent evidence. And I would just say this, I challenge the state to point to some independent evidence of the robbery. On the second issue of manslaughter, and I know I need to hurry, I'm almost out of time, but that is a lesser included of the felony murder. And we set out what the facts would be that would support a manslaughter. We have our client with a gun in the backseat of his car, a juvenile that's on drugs in the backseat of his car with a gun. That is the conduct that led to this offense, so it is factually a lesser included. It is legally, element-wise, a lesser included offense. The law says if there is a scintilla of evidence, you're entitled to your lesser included instruction. We didn't get the lesser included instruction, so the harm analysis, if there is a scintilla of evidence on either of those instructions we should have gotten, the harm analysis is this. If he'd been convicted of manslaughter, he would have been facing a 20-year maximum sentence. That's harm. If they had followed the corpus delicti instruction, he could have been acquitted. That's harm. And there is evidence to support both of those. And
What evidence is there about how Nava got the gun from your client? I'm not sure I recall the evidence that the gun was like in the car in a glove compartment and somebody got it. It was just all of a sudden Nava has it. And then obviously it gets back into the car somehow because it gets to Phoenix and gets thrown away at the bowling alley. But what do we know about how Nava got the gun?
We don't. I mean, other than Mr. Mailand's statements, we don't know, honestly. I mean, we know that a gun, and I mean, I think it's reasonable to assume that was the gun, but what Mr. Mailand says is, I kept the gun in my car. Mr. Mailand says, I didn't see him get it, but I don't think there was anything ever saying it was in the glove box. I think if anything, and I'm not positive about this, but I believe Mr. Mailand said he kept it either under his seat or on the floor behind his seat. That's what Mr. Mailand says. There isn't any other evidence about that, but that's what Mr. Mailand says. So, I mean, on the corpus delicti point, I mean, there is some evidence to support the fact that he's driving around with this gun. Even if it was under the seat, presumably it could have been on the floor. He's got Nava in the back seat on drugs, 17 years old, and there's a gun back there. That's our theory on a manslaughter charge, Your Honor. I think I am about out of time, but I guess I do have to say that with respect to the harm analysis, I sort of view it as a circular thing. If there's some evidence to support the defense instructions, then obviously there's some evidence that the jury or a juror could have accepted that theory. So I think the harm kind of proves itself because the outcome could have been so different. I mean, it's a little different than a harm analysis where you're saying there was an incorrect instruction because if they received the correct instruction. I couldn't argue for manslaughter because there wasn't that instruction. I couldn't argue for corpus delicti because there wasn't that instruction.
How does it work though when you have kind of law of the parties? In other words, if we're focused on Nava and Nava shooting this gentleman, is that where you have to find the recklessness, or is it some step before that? In other words, if either your client gave Nava the gun voluntarily or just had it in his car, if the jury says they're in this agreement that they're going to go steal some drugs, I mean, isn't your client kind of responsible for anything then that happens, from the co-defendant? In other words, don't you have to look at whether the recklessness would be appropriate as to Nava's actions, since he's the one who, I guess you assume, or you argue, pulls the trigger?
Well, and sure, if there was some other evidence of robbery, then you get there because then it's felony murder and you're responsible for whatever consequences. If I agree to rob a bank with you, then you go shoot somebody in the bank. Yes, I'm responsible for that. But that's what I'm getting at, is there was no other evidence of a robbery other than Mr. Mailand's statements. So if you don't have those, then you don't have the felony murder. Now, with respect to the manslaughter and the recklessness, the jury also could have discounted those statements about the robbery because they were, if you see the video, the detectives push that, but you were going to steal, and he denies it several times, and then he says, okay, yes, we were going to steal from him. The jury also could have discounted that, and I could have made a very straight face attempt to say an argument that there's not enough evidence of this robbery, convict him of the manslaughter. That's what we know he did. We know he drove, he had a gun in his car, he had a 17-year-old on drugs in the backseat of his car, convict him for that. And I could have done that, but I didn't have the instruction that allowed me to. And I think I'm.
You're a little over time, but that's fine. Thank you. Mr. Darnold.
Thank you, Your Honor. May it please the court, Ms. Stillinger. Real briefly, just on the evidence, just a snapshot of what happened. The evidence was that this defendant and his co-defendant, Nava, conspired together to go meet with a person who was selling drugs to rob him of those drugs. At the agreed upon meeting, there's some kind of argument and scuffle. There's a threat to kill the victim. The victim ends up with injuries on his face and hands that the medical examiner testified were consistent with being pistol whipped. He couldn't conclusively testify that that's what happened, but it was consistent with that. Then the victim was shot and killed with a firearm. The next day, the defendant left town to go to school in Tucson at the University of Arizona, and he had the gun in his possession, and he disposed of that gun, or tried to, in a bowling alley there in Tucson. Now, turning first to the claim of a Sixth Amendment violation due to the officers interviewing the defendant in Tucson after he had been appointed counsel, there's no dispute that he had been appointed counsel for the extradition proceedings when he was arrested in Tucson, and that he had, in fact, appeared in court with that counsel on those extradition proceedings. But just because he had counsel in that ancillary extradition proceeding doesn't mean his Sixth Amendment rights were violated. And there's two reasons for that, basically. The first reason is that in the facts of this case, his Sixth Amendment right to counsel in this criminal prosecution had not yet attached. The Sixth Amendment right is not triggered upon simply upon your arrest. It's only triggered upon the initiation of adversarial judicial proceedings in the criminal case. Now, the trial court may have indicated that because he hadn't yet been indicted, that the Sixth Amendment hadn't attached. But the indictment, we'll agree that the indictment is only one part of that question. The case law is pretty clear that it attaches, the Sixth Amendment right attaches either upon indictment or upon, like I said, the initiation of adversarial judicial proceedings, such as an arraignment, what we call the 1517 hearing, or a magistration. And none of that had occurred in this case, in this criminal case. He had been taken before a magistrate and appointed counsel, but that was solely for the extradition proceedings. That is not this criminal case. It's tied to this criminal case, but it is not, it's a wholly separate proceeding. There is nothing in the extradition proceedings that concerns itself with the guilt or innocence of the accused. That is just not what's at stake in those extradition proceedings. And the extradition counsel in no way represents this defendant in this criminal case.
Mr.
Chief Justice
Darnold.
Go ahead.
Sorry, go ahead. So I guess listening to your argument, what pops into my mind is then what's the underlying basis for the extradition proceedings other than this criminal charge?
It is this criminal charge is the underlying basis for the extradition proceedings. However, it's not the criminal case itself. It's an ancillary proceeding, and the Sixth Amendment is offense specific. And to answer Chief Justice Alley's question earlier, even though it's offense specific, and Ms. Stillinger said that if the two cases are related, then it applies. It doesn't have to be an unrelated case. Even the case law is clear under the Sixth Amendment that if the one I'm thinking of, and I can't remember the name of it, the person was arrested for a burglary in which somebody was ultimately killed. The officers, he had counsel on the burglary case, but investigators or officers investigating the murder went to talk to that defendant about the murder. And even though it was all one transaction, the result was his Sixth Amendment right to counsel had not attached in the murder because he had not even been arrested on that case yet. So even though it was all one big transaction, the Sixth Amendment is offense specific. And it's exactly the same here. The extradition may be related to this criminal case, and it's definitely tied to this criminal case, but it is not this criminal case. And the Flores case from this court is the only case that I was able to see where the idea of whether the Sixth Amendment attaches in extradition proceedings occurs. And this court unequivocally said that it does not attach. The appointment of counsel for the extradition proceedings does not trigger or implicate the Sixth Amendment in the underlying criminal case. And I will disagree with Ms. Stillinger's description of the Flores opinion. She asserted that this court never held that there was no error, that only if there was error, it was harmless. That's not a correct reading of the Flores case, where this court specifically said, in light of the ruling in Montejo, we find that the court did not err in admitting the video recorded statement. So this court unequivocally found that because of Montejo, there was no error in admitting the statement in that case. Now,
Mr. Donald, can I just ask you to address, let's, setting aside for the moment as to whether or not the Sixth Amendment attached at the extradition proceedings, can you speak to the voluntariness of the appellant's waiver of counsel, if any?
Absolutely, Your Honor. And that ties into the second argument that even if the Sixth Amendment had attached, under Montejo, it was knowingly and voluntarily waived. There's been no challenge either in the trial court or in this appeal that his waiver of his right to counsel was in any way involuntary or unknowing. And in fact, when the detectives in Tucson, the Tucson police detectives first questioned him, they asked him if he wanted to speak to the El Paso police. And he said, yes, I do. I just don't want to go to El Paso to do it. So then after he was arrested, the El Paso police officers go to Tucson and questioned him there. And under Montejo, this was perfectly lawful. He had the Montejo court held that even if the Sixth Amendment right had attached, that right to counsel is fully protected by the Miranda type protections normally associated with the Fifth Amendment. If the defendant doesn't want to talk to the police, all he has to do is say, no, thank you. And then under the Sixth Amendment or the Fifth Amendment, the officers would have been precluded from speaking with him. He was fully advised of his rights. He voluntarily waived those rights and said, I want to speak to you officers. And then he did that. He never, during the interview, never said, you know, I want to end this interview, or there was no badgering type situation where he invoked his right to counsel and then the officers later came back at him again. None of that ever happened in the Sixth Amendment or Fifth Amendment context. He said he wanted to talk to the officers. They met with him. They asked him, they advised him of his rights. Do you want to talk to us? He said, yes, I do. And they interviewed him. Under Montejo, there was nothing improper about this conduct by the police. And for all of those reasons, the defendant's first issue should be overruled. Turning to the second point of error, the defendant makes Bruton and Confrontation Clause claims. The complaint of statements, it was not where the officer on the stand simply told the jury, Nava told us that the defendant did it. That's not the context of these statements. The context of these statements were that it was the officer's interview with the defendant where they told him, pardon me, 1 second, Your Honors. Sorry, I forgot to mute my office phone. The officers told the defendant as they were interviewing him, well, Nava said you did it. They may have said that a couple of times. And so I'll now address both parts of the claims, the Bruton and the Confrontation Clause. Quickly, the Bruton claim fails for two reasons. This part of the claim just was not preserved for review. They filed a pretrial motion in limine raising the Bruton issue, and at the pretrial hearing on the motion in limine, they simply asked that the state approach the bench out of the jury's presence before getting into the statement because of Bruton, and the state agreed and the trial court agreed that's what would happen. During trial, when the state endeavored to offer the statement, the interview into evidence, there was no Bruton objection made during the trial. And the law is very clear, it's cited in the brief, I believe, that a motion in limine is not sufficient to preserve error. You still have to object at trial on those grounds to preserve the error. Since they never raised the Bruton claim during trial, that part of this issue should be overruled. But even if it was preserved for review, Bruton is just not implicated in this case. The Bruton rule from that case itself in the US Supreme Court applies only when the co-defendants are being tried jointly, and the non-testifying co-defendant's confession is admitted into evidence. The Bruton case says in that context of a joint trial, the non-testifying co-defendant's confession cannot be admitted. And the rationale is that an instruction to the jury that you can consider the confession against the co-defendant, but you can't consider it against this defendant, just doesn't work in the context of a joint trial. Here, this was not a joint trial. When the statement was admitted into evidence, the state agreed and the trial court instructed the jury that they were not to consider this confession, or it wasn't a confession, they were not to consider Nava's statements as evidence of this defendant's guilt. And the cases are clear that this type of limiting instruction is perfectly sufficient to protect the defendant's rights, confrontation rights, or whatever rights in the context of a non-joint trial. So because Bruton simply doesn't apply, even if it was preserved for review, this part of the second point should be overruled.
Why does an instruction, why does an instruction work when they're tried separately, but it doesn't work when they're tried together?
The case law, the Bruton line of cases has reasoned that if there's a non-testifying co-defendant who has confessed and the defendant has not confessed, then there's just too great a risk that the jury, even if they're instructed that they can use the confession only against one of them, there's too great a risk that they'll just apply it to both of them in the joint trial. But that, again, it's expressly clear that it's only in the context of a joint trial that rule comes into play. As far as the Confrontation Clause claim, the Confrontation Clause is not implicated or violated by the admission of any kind of testimonial statement. It's only testimonial hearsay that implicates the rule. And here, again, I'll disagree with Ms. Stillinger that this novice statements to the officers do not fall within an exception to the hearsay rule. It's not hearsay that's otherwise admissible. These statements were simply not hearsay in the first place. There's a difference. It's not an exception to the rule. It's not covered by the rule. And the opinion from this court that she cited that says even if some evidence may be admissible under an exception to the hearsay rule, you still have to deal with the Confrontation Clause issue. That does not apply here because this is just not hearsay to begin with. And I would cite the case cited in the brief, the Velasquez case from this court, where this court made that distinction, that if it's not hearsay, the Confrontation Clause in Crawford just doesn't apply. And that is in Crawford itself. And in this case.
So wait, on that point, you're saying that you would have, that this particular statement is not hearsay at all? Is that your point?
Your Honor, because it was not being offered for the truth of the matter asserted. Hearsay is only an out-of-court statement that's being offered to prove what is being said. And in this case, it was the state made it perfectly clear on the record, and the trial court instructed the jury that none of Nava's statements were being offered to prove what he said. The state didn't offer Nava's statements to prove that the defendant was the shooter. They offered those statements to show how this defendant reacted to it, or to show the context of the interview. It's just a question.
Right, but so do we look at the nature of the statement itself, or do we look at what the state offered as the basis for the reason they were going to use the evidence?
Both, Your Honor. And to answer your question of Ms. Stillinger, it does, you asked whether it mattered that the statement was from the officer to the defendant and not just coming from Nava himself. And it does matter because it factors into the determination of, was it hearsay to begin with? Here, like I said, the officer wasn't on the stand just telling the jury, Nava said he did it. That was not the context of this statement. The statement was just the officer's interview and questioning of the defendant. And there's a long line of cases, including the Mendez case from this court, where holding that those kinds of statements from the officer to the suspect during the questioning are not hearsay, because they're not being offered to prove the truth of what they're confronting the defendant with. It's just
okay, so they're just questions during an interrogation.
In a nutshell, that's exactly it, Your Honor. Because that statement may or may not have been true. It didn't matter if Nava actually said that this defendant was the shooter. That doesn't matter at all. And that's not what the state was trying to prove with those statements. What mattered was how did this defendant react and how did he answer that question? When the officer says, Nava said you did it, what do you say about that? And he says, I didn't do it, or I did do it. So the actual statement from Nava to the officers as related to the defendant is just not being offered for the truth of what Nava purportedly said. And that completely takes it out of the hearsay realm, which completely takes it out of any confrontation clause issue. And again, the Mendez case that's cited in the brief is very similar, where the officers confronted the defendant with what another witness had said, and the confrontation and hearsay challenges in that case were rejected by this court correctly, because the officers confronting the defendant with those statements just does not constitute hearsay. And for all of those reasons, the defendant's second issue should be overruled. Okay, quickly on the jury charge points. I'll talk about the manslaughter charge first very quickly. Manslaughter can be a lesser included offense, but again, just because it's a lesser offense, under the facts of the case, it has to be a lesser included offense. And that's where the evidence fails in this case. To be an included offense, the evidence raising the reckless conduct has to be the same conduct that actually caused the victim's death. And in that regard, this case is really legally and factually indistinguishable from the Appilato case that's cited in the brief. There's really no legal or factual difference in those cases. Appilato was charged with killing his father, murdering his father, shooting with a firearm. And the defendant argued that reckless manslaughter was raised because there was evidence that it was reckless for the defendant to even have a gun in the house, knowing that he had a propensity for sleepwalking and something bad could have happened while he was sleepwalking. This court correctly ruled that that doesn't matter, because the conduct of just keeping a gun in the house or having a gun present, even if it was reckless and stupid because the guy might go sleepwalking, wasn't the conduct that caused the victim's death, which was shooting him with that firearm. And it's the exact same thing here. No matter how reckless or stupid it may have been to have a gun in the car when you're going to meet a drug dealer, that was not the conduct that caused the victim's death, or that was alleged in the capital murder or murder application paragraphs in the jury charge to have caused the victim's death. All of those, it was very clearly alleged that the conduct that caused the victim's death was shooting him with a firearm. Having a gun in the car is not shooting him with a firearm. So for those reasons, it just...
Isn't there a link there, though? How do you shoot the victim without having the gun in the car?
You probably can't, but it's different conduct. You can have a gun in your car 24 hours a day and nobody dies. Nobody dies until somebody picks up that gun and fires it. That was exactly what happened in Appilato. So even if it was reckless or dumb to have the gun or take the gun with him, that is not the conduct that caused the victim's death. Ms. Stilger argues that the jury could have discounted all of the robbery evidence and then disbelieved the robbery evidence, and therefore manslaughter was raised. But that's not how you get a lesser included offense. There has to be some evidence affirmatively refuting or denying the elements of the offense. Here, there was no evidence denying or refuting the robbery element, and the fact that the jury didn't have to believe it was not enough to get there. So even if this court were to determine that, well, he was reckless for having a gun, that still doesn't, having a gun in the car, that still doesn't get you to manslaughter, because if that was the conduct that caused his death, it was still during the commission of a felony, and therefore it's murder. It's not manslaughter. Appilato was a little different. There was no other associated felony. So if this court had determined that his recklessness in having the gun was the cause of death, that would have entitled Appilato to a manslaughter charge. but it wasn't the same conduct. But here, even if it was that recklessness did cause the death in some kind of proximate cause kind of analysis, that still doesn't get in manslaughter. That still gets in murder because of the associated felony. So there's no way they can get a manslaughter charge in this case. And that third issue should be overruled. Finally, on the corpus delicti instruction, the corpus delicti, the independent evidence, other than the defendant's out-of-court confession, need only tend to show that an offense was committed. It doesn't have to touch on all the elements of the offense. It doesn't have to prove the offense. It just has to tend to show that the offense was committed. It's a very low threshold. And specific as to murder, which was what this defendant was convicted of, it was murder. The corpus delicti rule is satisfied if there's some evidence of, one, the death of a person, and two, that it was caused by the criminal act of another. And I don't think there can be any question that those elements were satisfied. We had our dead victim who was shot with a firearm.
Well, but as I understand the argument is that because it's felony murder, they're saying, okay, what's the evidence that there was a theft? I mean, I guess clearly there's some evidence that there was a drug deal, because I guess there were 2 vials of whatever the stuff was. But is there any evidence that Nava was actually trying to steal something from the decedent?
Right. And the response to that is twofold, Your Honor. First is, because this was murder, yes, it's felony murder, but it's still just murder. The B3 murder, the felony murder, is just one alternative manner and means of committing the offense of murder. It's no different than intentional and knowing murder, or intending to cause bodily injury and committing an act clearly dangerous to human life. Those are all just alternative methods of committing the offense of murder. We call this felony murder, but it's still just murder. Ms. Dillinger, in the cases she cites, deal with capital murder. That's a different offense. Capital murder, the Court of Criminal Appeals has determined that the corpus delicti rule applies to the underlying felony element of capital murder. This is not capital murder. This is just murder. So no court, to my knowledge, in Texas has extended that corpus delicti rule to the associated felony in the B3 felony murder situation, because it's not capital murder. It's just a species of murder. And to prove, and again, I'll go back to the corpus delicti. It doesn't have to, there doesn't have to be evidence of all the elements of the offense. It just, the independent evidence just has to tend to show that the offense was committed. And I see I'm out of time. If I may briefly finish my answer to your question, Your Honor.
Yes, if you hadn't already.
Well, the second part is, even if there was some requirement of some independent evidence of the associated felony, it was presented in this case. Again, we have to keep in mind that the corpus delicti rule, it's a very low threshold. It doesn't have to establish the associated felony or underlying felony. It just has to tend to show that it may have been committed. And here, the victim agreed to meet with Nava to sell him drugs. During that meeting, there was a loud argument and scuffle. Someone threatened to shoot the victim. The victim sustained injuries consistent with being beaten, pistol whipped, or beaten about the face and head. And then there were drugs strewn about the victim's body in the street. All this evidence tends to show that there was a robbery or an attempted robbery. There's a lot of cases dealing with the corpus delicti of robbery, and they're not cited in the brief, but one case that comes to mind is a known prostitute was found dead. He was a male prostitute, and the defendant was charged with capital murder during the commission of a robbery. So they did have to establish the corpus delicti of the robbery aspect as well. And in that case, there was evidence that, well, this person was a prostitute, so he probably had cash on him. There was no evidence that he had cash on him, just a reasonable deduction that he probably had cash on him. There was evidence that he normally carried a brown purse with him. And he was seen with a purse earlier in the day before the murder. There was no evidence that he had that purse on him at the time of the murder. And there was evidence that somebody was seen walking near the scene of the offense carrying something. And the court in that case, it's an unpublished case from the 14th Court of Appeals, and I'll provide the court with the site. It's Williams v. State, 2017 Westlaw 6559747. In 2017, out of the 14th, the court held that evidence was sufficient to satisfy the corpus delicti rule, and that it tended to indicate that there might have been a robbery involved. Even though it was really pure speculation, or not pure speculation, those were just deductions that could have been made from that evidence. It was enough to tend to show that there had been a robbery. And this case.
I was just going to thank you, counsel. I think that answered my question.
Okay, very good, Your Honor. With all of that, the state would respectfully pray that the defendant's conviction and sentence be affirmed. Thank you.
Thank you. Ms. Stillinger, do you have any rebuttal?
I do, Your Honor. I guess first, I think what I heard the state say is, I think that they agree that the judge's finding that the Sixth Amendment did not attach because he had not been indicted. I think I'm hearing the state agree that that is not a correct finding. But the state is relying on the fact that it is an extradition, it's an ancillary proceeding. Mr. Darnold argues that guilt or innocence is not the question to be determined in an extradition, but I don't think there can be any serious argument that you don't have a Sixth Amendment right in an extradition proceeding. One of the things we cited in our, I'm not sure if it's in the brief or in the motion initially, but the law provides for counsel in an extradition proceeding. Mr. Mailand had appointed counsel because he had a Sixth Amendment right to counsel in an extradition proceeding. There is, you do have due process rights in an extradition proceeding. If there was nothing contested, then you wouldn't get a hearing. You'd just be shipped back to Texas. There are issues, certainly identity. There are some defenses to extradition that can be waived and can be defeated by the detectives going behind the lawyer's back and getting a statement from the defendant. I still also think that it is not a separate offense. It's offense specific. Mr. Darnold cited a case where there might be one course of conduct, but different offenses, maybe a burglary, but there's a murder involved, something like that. This was one offense, and we know that it's on the record in Arizona. You're charged with capital murder in Texas. That's all we're talking about. That's what the detectives went to interview him about. That's what the lawyers were representing him on in court that morning. The voluntariness of his waiver, we did raise voluntariness of his statement. We raised it to the jury. We got an instruction on that. We did raise voluntariness with respect to some parts of the statement. We did not actually raise it with respect to the waiver. We raised it later because the detectives badger him, and he's 18 years old. But with respect to the waiver, Mr. Darnold is right. Mr. Mailand is the one who first contacted the officers. This is before he's arrested. He contacts the officers on Wednesday of that week. He gives a voluntary non-custodial statement on Thursday, where he does not make any admissions. Then he gets arrested Thursday night, goes to the jail, appears in court Friday morning with his attorney, and then it's Friday night the detectives come and get his statement in which he ultimately confesses. But voluntariness is not the issue, even under Montejo. That is the reason maybe behind a prophylactic rule, but Montejo still, as I said when I started out, there still is an exclusionary rule that if somebody has invoked and you go back to them, and it might even be completely voluntary, I invoked, but I changed my mind, I'd like to talk this time. Even under Montejo, they say a subsequent waiver is invalid. You don't do a voluntariness analysis, you do the analysis of, were the officers, were they entitled to go back and question this person after he invoked? And the answer is no. In this case, it was not an invocation, but it was appearance in court in an adversarial proceeding, which was a bond hearing. And that's, I think, basically it has the same effect as an invocation. You're receiving assistance of counsel in a contested proceeding. They can't come question you about the facts pertaining to that proceeding.
Do we have anything in the record on that proceeding? I think it was in Montejo, they made the point that the defendant just kind of sat there at the table and the judge appointed counsel. Is there anything here about him saying anything or being asked any questions? Do you want counsel? And he says yes. Is there anything like that from the extradition proceeding?
Yes, actually, we have the recording of that proceeding. So it wasn't just, Mr. Mailand was actively represented. He was appointed counsel, and that counsel represented him at that hearing. So Mr. Mailand was not doing the talking. It was his attorney doing the talking. The attorney argued for bond. The attorney said, this is a young man. He came here to go to the University of Arizona. We're asking for a bond reduction. And that recording is an exhibit, the suppression hearing, Your Honor. So there was active representation. The state's attorney said that this is a capital murder case. He's looking at the possibility of life, maybe death penalty. I don't remember if he mentioned the death penalty at the bond hearing, but I know the attorney for the state mentioned this is a capital murder case, Your Honor, and the bond was denied. So that's what I'm saying. It's very different than these other cases where somebody's just appointed and it's a matter of a document. Or Mr. Mailand met.
Okay. Stillinger, can you hear me?
Oh, no.
Oh, no.
Oh, no. It just froze.
Yeah, okay. Let's see if you can stop the time, please. Good. We may have to wait for her to sign back in. And the problem is when you're frozen, you don't always know it. And so she could be there. She's popped out. Now we'll have to wait for her to pop back in. You're back.
Okay.
Okay, yeah, no, you froze, and I thought you had just explained what had happened at the extradition hearing, and there's an exhibit, and I appreciate that. So you can return to your argument, and we stopped the time, and so we'll start it again.
Thank you. I think I just
Wait,
was
can
the last thing I said that I'm not sure that you heard was I think that's a really important distinguishing fact that they were had a contested hearing on a capital murder charge, albeit under the rubric of an extradition proceeding. I do want to say one thing about Flores. I'm sorry, Judge.
Oh, I'm sorry. Could you tell me one more time why it is that it wouldn't have been a voluntary waiver of his right after the extradition hearing? After the contested hearing, he goes back to the jail and then voluntarily waives the right to counsel.
Well, what Montejo says is you don't look at his conduct. You don't have to look at voluntariness. You look at were the officers allowed to do what they did, and the answer is no. So Montejo, and this is actually quoted, I think, in the Flores case, that they say in Montejo, if the defendant has invoked, officers can't go back and ask again. It does not, you do not do a voluntariness analysis at that point. Even if the defendant says, I really want to talk to you, I'm so glad you came back for X, Y, and Z reasons, I'm really happy you came back and I want to waive now, officers can't go back after invocation. And my argument is that a contested proceeding where you are represented by counsel is basically the functional equivalent of invocation. You are actively receiving services of counsel. You are being actively represented. And the officers are not allowed to go behind the back of your attorney. And that's what happened here. Flores, I just want to say this about Flores, because I know Mr. Darnold said I might have misspoke about the holding. He is right that the court says in light of Montejo, we find the court did not err, but the court does go on to say, so maybe it's just a watered down holding. They go on to say, but even if there were error, it's harmless. And so I don't want to have misrepresented that. Maybe it's just a weaker holding, but Mr. Darnold is right. They do make that finding. With respect to the confrontation clause issue, I want to say I have a habit of saying brute, and it's really, and I said this in my reply brief, it's a colloquialism. I'm not saying the facts are identical to Bruton, but in the pleadings in the court, we specifically identified the Sixth Amendment. And when those statements were coming in trial, I did object again, and I did refer back to our written motion in limine, which cites the Sixth Amendment. I did not make all of those arguments again, but I referred back to them, which preserves it. I think the issue is absolutely preserved. One of the cases Mr. Darnold mentioned several times is Mendez. I just want to say Mendez is inapposite. It was not a confrontation clause issue. It was a hearsay issue. And in that case, the declarant actually testified. So it was admissibility of a prior statement, but it had to do with somebody who was there and was available for cross-examination. So I don't think it has any applicability in this case. One other thing I want to say in rebuttal, referring to the Appilato case, I have a footnote in the reply brief. In footnote 8, we explain why Appilato is not the same case. In Appilato, the person who is charged with doing the shooting is the one who says, I should have gotten the manslaughter charge because I had a gun in my house and I sleepwalked. This is different because Mr. Mailand had a gun in his car in his back seat with a young man who was on drugs. That young man ended up being the shooter. So it is the exact same conduct. What he did was the exact same conduct. It factually, evidence-wise, is a lesser included. Finally, with my 40 seconds left, the prostitute case that Mr. Darnold mentioned right now about the prostitute who was murdered and she was missing money and they saw people leaving. In this case, Mr. Jajorian was found with the drugs on him. You know, that they were there. So yes, there was a threat overheard. I'm going to kill you. That doesn't say I'm going to kill you if you don't give me the drugs. I'm going to rob you. It was a threat to kill. He had the drugs on him. I still say there is no evidence. The pistol whipping, the officer, the medical examiner said equally consistent with somebody falling over and hitting their head on the sidewalk, which is what Mr. Jajorian was seen having done. So there is not real evidence of pistol whipping either. And I think I'm done with my time if there aren't any other questions.
All right, counsel, we thank you for your excellent argument and your excellent briefing in this case. Case will be submitted on that briefing and argument, and hopefully you'll hear from us soon. So with that, thank you very much.
Thank you, Your Honor.
Thank you.